Okay. All right.
Your Honor,
The records for your court is now in session. Please see it.
once again is 1780 CD 033, Patrick Buchanan et al. Versus the City of Greenfield.
All right.
Without the jury.
I just want to get us started because in my mind there's a limited amount of work that we need to do so that I can go back there and start finalizing the jury charge. This is what I perceive to be our agenda, so to speak, for this morning. One, argument on the motion for a directed verdict the renewed motion for a directed verdict as it relates to Mr. Buchanan. I believe that where we last left off, we were awaiting Attorney Ryan's opposition, which we now have, and I've reviewed. And I had agreed to start our charge conference and then hear the renewed motion this morning. Second, I just received Attorney McDonough's supplemental jury instructions, which I asked Attorney McDonough to go through and show us where this differs from the old one, because just to be honest, for me now to go through this and see how this differs from your old one is a lot of work. And you've just handed this to Attorney Keston, and so Attorney Keston, please understand, we're not going to dive right into this. I'm going to give you an opportunity to review this. So we're going to take a break after the motion for directed verdict for that purpose. I'm not going to belabor points that have already been articulated. So what I'm looking for is what's new in here, okay, so that I can give some thought to it and give counsel an opportunity to lodge his objections. But once again, we're going to take a break so that Attorney Keston and County I can go through this and see what this is all about. One question that I want to be perfectly clear about: does this supplemental request for jury instructions replace at least part of your earlier filed jury instructions? And if so, what part? Is this in addition to it? What is it?
It's in addition to the request to instruct the jury on all three categories on the whistleblower statute.
So you want
limited to that.
But my point is that you want this in addition to what you've already requested.
It's the same. It's the same.
That's why I'm trying to clarify this, and truly, I need to figure out what you're doing here, because if some of this already exists in what I've reviewed, I don't need to review it again, and we're not going to go back through it. That's why I want to know what was in the old one, what is not. So some of this, though, I take it, is new.
Yes, Your Honor.
Okay.
If I may just, in 2 sentences, explain what this is. It is 3 requests. The 3 requests are the 3 versions of the law. And then A is just quoting the statute, what the law provides. And then B is why. And the case
I get it.
law.
I've seen it. I've reviewed it. But all I'm looking at is, and my only question is, what is new?
The case law, the examples of other cases with similar conduct and is new. So, like, for instance, in Section 3, I say quasi-mila.
Let's just do this. It's not that many pages, okay?
Right.
But this will inform our discussion, okay? Because if I've already looked at this, I'm not looking at it again, okay? I'll consider in the context of what is new, but we're not going to re-argue it. So on page 2, okay, is there anything on page 2 which was not set forth in the initial request for jury instruction?
This page 2 is the same request. It just uses the statute instead of Edwards.
Okay, so this is the same, so we need not go back to that because we've already discussed it.
And it provides the definition of a public file.
Okay, once again, what is new? Not what is it. What is new? So what is new on page 2?
The holding of the SJC, specifically in Edwards.
On page 2?
Oh, I'm sorry. I'm sorry. I thought we were on page 3.
Yeah,
Excuse me.
and on page, I'm on page 2.
The definition of the public body, Your Honor.
Okay, so the very bottom, that continues to the next page, is that correct?
Yes, Your Honor.
Okay, so that definition is new, right?
Yes, Your Honor.
Okay. Now we're making some progress. And I'm still going to give you an opportunity, Attorney Keston, to go back and review this. I just want to know what's new. Background, this is not part of the charge that you're asking me to give.
Absolutely not, Your Honor.
Okay, so that is just for my information.
Yes, Your Honor.
Okay, so that's page 3, that's page 4, that's page 5. Now I'm up to page 6. Proposed instruction. Is this already set forth?
It is, Your Honor.
Okay, so that's not new.
What's different is that I just used this, what the statute provides, instead of citing to Edwards as I did the first time. If the court finds this to be a more clear, there is no MCLE version of what to give, and so I've just tried to simplify it.
Were these 5 lines verbatim in your first request?
I think that I have the court's citing to these lines, Your Honor.
What page are we looking at?
We're on page 6. I'm not interested in citations because those don't go in the jury charge.
They're not verbatim. No, they're not.
No. Okay, so this is new. And what page was this on of your old one?
It would be the section with the heading protected activities.
And what page is that?
I have to pull it up, Your Honor. I don't have it in front of me. I just don't have, I do not have the page in front of me. Your Honor.
Okay, so the section on protected activities. Okay, we'll find it. And then the rest is just argument.
The rest is correct.
Then, now I'm on to page 8.
And again, this is the B3, the third protected activity category.
I understand what it is. My question is this in your original request?
The language is slightly different, Your Honor. In the original request, I was providing you the language as described in Christo and Edwards. This is just straight from the statute.
Okay. And what page is that on, or what section?
It would also be under protected activity, Your Honor. It's about a 2-page section where I went
Okay.
through all 3. I've just broken them into 3 parts here.
Okay. Then I've got background.
And this is all completely new. The case is quasi.
This is just argument, though.
Cases. Yes, Your Honor.
It's just argument.
Right. It's to supplement what my response to you yesterday, which I just was a little flat-footed. And here are cases that I believe are directly on point.
Right. Okay. Okay. So that positions us, counsel, you'll have an opportunity during the break. I'm not going back. I'll read this.
Thank you, Your Honor.
But I may not deem it necessary to entertain further argument because, Kenley, we need to move forward.
Thank you, Your Honor.
But I'll give Attorney Keston an opportunity to reply after he has had a chance to read it. Okay. Then the other issue is the jury verdict slip, which I understand I've gotten 2 proposed drafts here to continue working on that. So the only thing I want to talk about right now is the motion for directed verdict on Mr. Buchanan. And so here, Attorney Keston, if there is further argument that you wish to make, I'm happy to start off with you. I know you made some argument, but indicated that you wish to defer until you received an opposition. Then I'll turn to Attorney Ryan.
Your Honor, the issue is that the argument is regarding certain portions of the various actions. There's a number of actions over a number of years in this case. So the first one, they say they should go to the jury.
You know what? Let me do one thing. Let me get my computer. I apologize. Let me just grab my computer and then I'll take my notes on that. Pardon me.
Wait, which one? That's not cited in there.
Quasi, you must look up. For some reason, my computer.
Okay.
This one's the red flag.
One moment.
I know. Okay.
Okay, thank you. If you could take it from the top, please.
Take it from the top?
Yeah.
Okay. There's a series of events in this case, and each one has to be taken separately to figure out which one can go to the jury, which one can't. So first event, they say, the first event in this case is they say that there was a short list in 2014 and that the city of Greenfield discriminated when it didn't promote him off the short list. And we say the evidence in this case, the uncontroverted evidence case is A, they don't have to, that it was the mayor's decision, not the chief's, and that the mayor just didn't want to. So they would have to have evidence that the mayor did it with racial animus. So, they like to lump it all together, but that's the evidence. There's no other evidence. And they try to compare it to Westerling. Again, it's the mayor. Westerling was a veteran. And the evidence, again, uncontroversial from both the mayor and the only two people, actually I think in Williams, is that the mayor promoted Westerling because he was a veteran. And that the mayor then didn't want to promote anybody off the short list. They are asking you to send to the jury the question whether the city's discretionary, they didn't have to promote anybody. That their decision not to promote Buchanan, or Haskins, I guess, off the short list was motivated by racial animus, and it has to be by the mayor. There's no evidence the chief had anything to do with it. Or anybody else. So we say that should be out. The next decision is the decision to initiate. See, again, it's all broken down. This is to initiate the IA regarding the stop and the gift card and the order. I don't think there's been any evidence that said that that was discriminatory to have an IA, to initiate it. Then we get to the decision to punish. And we're not arguing that that doesn't go to the jury. That the chief, if they have enough evidence, and I'm really not going to seriously argue that, if they have this evidence.
You're referring to the 3-day suspension, not the later 2018.
Yeah,
right.
That's what I'm going event by event.
Right,
So
okay.
now we have, they impose a 3-day suspension. And they say that the chief gave him, and by the chief, when the chief imposed it, that the chief gave it to him because of the chief's racial animus. Well, we're going to maintain the position that there's no evidence the chief had racial animus. I understand what the court's likely to do about that, but there's no evidence. So that conceptually could go to the jury. Tell us whether that demotion. Now, they want to argue that the demotion from provisional sergeant that went along. And we say they can't. The arbitrator upheld it. There was a decision by the arbitrator that the motion was appropriate. So that takes care of that, and that's the 2015. Then nothing happens, and then we have his promotion, and then we have the IA instituted by the officers and the union, patrolmen's union, blowing the whistle on Mr. Buchanan.
And that was 2018, if I'm correct?
Yes, sir. That's when Corey Green, the then president of the patrolmen's union, brings complaints by various people. And they would like you to allow the jury to consider whether that was motivated by race. There's no such evidence. That's why in this case, it's so complicated with all these events, it has to go piece by piece, I suggest. So we have an IA is instituted. And as a result of the IA, Buchanan gets a letter of reprimand. That's it. That was the Donovan report. And he gets a letter of evidence. And suggests there's no evidence that Donovan was motivated in any way, shape, or form by racism. I don't see how. I suggest it's inappropriate that should be directed out. That the letter of reprimand that he got as a result of that IA, the jury could find was motivated by the chief's racism. So you have that decision in question. Subsequent to that, he is removed from being a provisional sergeant, unrelated to the IA, temporary but unrelated. And the chief articulated the reasons. He sent him a letter.
Now, this is 2021?
19, I believe.
2019. Okay.
A couple of months after the IA.
Okay, got it.
We'll get the exact time frame, but he is demoted. The chief says we need more
Right.
patrolmen, and we're removing you. Thank you for your service. He writes him a nice letter. So there's a question. We say that decision to not be going to the jury is something potentially motivated by the way, a statement the chief made at this point years before. Years before. That statement allegedly, the statement was made in 2014. And this is 5 years later. So then we have I'm going to back up, Your Honor, to the 2015 Civil Assessment Center. If I may, I forgot that one. So after the investigation, he goes to an assessment center. His only evidence coming out of Patrick Buchanan's mouth is that he didn't get the job because of the unfair demotion from provisional sergeant as a result of the complaints, as a result of the discipline, which was upheld by the arbitrator. He says that he didn't get the job, he didn't finish the top 2 in 2015 because he didn't have, had he had more time as a provisional sergeant, somehow he would have gotten a better score. That's it. That's all they got. There's no evidence from which the assessment center was rigged. There was a fair assessment center, and that's what Patrick Buchanan said. And what he also said on the stand, Your Honor, when I asked him why he thought he would have succeeded, he would have gotten a better grade, what he said is, I felt it. I'll get you the quote. I felt it? I felt it in my heart. I think so. That's his basis. And my memory is he put his hand on his chest and says, that's what I think, but I would have. That doesn't get you there. I mean, if it's a fair process, and the jury would have to find, or somehow be instructed that they find that if he had stayed as provisional sergeant for 4 more months, he would have gotten a higher score. That's complete and utter speculation for a jury. So that's the 19 process. Then we get to the 2020/21. They're out of civil service. And there were 2 things that happened, Your Honor. Originally there were, I think, 4 or 3 openings for sergeant. And they had the non-civil service process, at which time the chief met with all the supervisors, and Lieutenant Dodge told him he shouldn't be hiring the plaintiff. That's when we had those notes of what Dodge said to the chief, and others said to the chief about the candidates. As a result of that, they designated, was it 3 at the time, then went to 4?
You're arguing, not me, brother.
Okay, it does, 3. I believe 3, I might be wrong, I might be 4, but they designated 3. Buchanan finished 5th. They designated people that finished over him. Then before they actually promoted, Deputy Chief Williams left for East Longmeadow, did not retire, as Mr. Ryan said. He leaves for Longmeadow, and they hire a 4th, and they hired the number 6 candidate and not Patrick Buchanan, number 5. And that's, the chief said it was his call.
It was what?
I mean, the chief agrees that that's what he recommended.
All right.
So, well, I think it's still temporarily removed. I get it. At least that was the chief's call. Those are all the various events. A finding on any of them, to the extent you send, whichever ones you send to the jury, I assume you will send some, you send to the jury, then we get into damages. Because his damages in this case are the lost wages. And I've had an exchange of information with Mr. Ryan about whether the jury could calculate that.
Could do what?
Whether the jury has anything from which they could calculate them.
I'm sorry, I didn't understand last.
Whether the jury has any evidence from which they could calculate the damages.
Oh, calculate
They have
it.
to tell them, for example, if they find that the 2021
Right.
promotion, that was the one that was discriminatory because he didn't get it, he gets damages from January of 2021 till November 2nd.
Right,
That's it, the differential.
right.
Now, this is what I don't remember we haven't a chance to listen. There was a chart presented, if you recall, Your Honor. You let me
Oh,
use it?
yes, hold on. We have that right up front here. Do you have the, bear with me a brief moment. Or do you have the chalk, or let me tell you what it is. Hold on. Indeed, let's talk about that.
Was it A for ID, Judge?
Probably.
Yes.
Okay, A for ID, where Mr. Buchanan's calculations, which I said I would consider allowing those to go to the jury, and those set forth lost pay for, here we go, different time periods. Right, this was the chalk. Okay, go ahead.
What I don't know, Your Honor, because I haven't had a chance to go back and listen, because there were no documents introduced from which this chart could be made. Mr. Ryan indicates that he believes that Mr. Buchanan testified as to the rates. I'm not sure of that.
Well, I can tell you what he said.
Okay.
Calculated lost wages using the first grade sergeant pay and patrol pay. He also receives incentive pay under the Quinn Bill and longevity pay and holiday pay. And then we kind of ran through this document for the different time periods, noting, for example, loss in step increases, differential in pay from first grade sergeant, I guess, to top sergeant pay, and indicating that he testified there were three tiers to get to the top step, and at the time he was in year 2. Now he's talking about, I guess, the period in 2019. So that's what he testified as to. So that at least is in evidence. And I indicated that while it was being introduced as a chalk, I might consider letting it go to the jury, which I'm inclined to do, only because the calculations or the document itself is probably about 20 pages.
Your Honor, what I ask is, I just want a chance to hear what he actually said.
Sure, I can tell you what time it was. Hold on.
That'd be great. And, Your Honor.
Wait. Just 1 moment. Bear with me a brief moment. Okay, that was 11/19 on, 1 moment, April 13th. Go
So
ahead.
I just want to take a look at it to see, was there competent evidence upon which the chalk took place? And if there is, then, I mean, I still object to the chalk, but at least that's enough for a jury to calculate.
We could address that tomorrow, rather Monday.
Yeah, I mean, I just need to look,
I respect that, that's
If you have
fine.
a chalk, you have to put in the underlying evidence.
Well, but we'll address it Monday. The underlying evidence here was testimony. It wasn't.
If he actually gave you numbers. So that's my question. I don't think you can just say
Yeah.
it's a chalk.
Well,
But anyway, I don't know.
right. We'll have a
look at-
copy of the chalk made for counsel. So, all right. I'm still listening. Go ahead.
I think
That's it.
That's it, but you know, what this is.
All right. Well, I appreciate your setting those forth out with some clarity. So, addressing them separately.
One more thing, Your Honor, just to raise on the directed verdict is the Confederate flag. The only reason, as I understood it, that you allowed them to put that into evidence is to demonstrate Sergeant McCarthy's state of mind.
Attributable bias.
Well, Sergeant McCarthy's state of mind, yes, and at the time, there was a cat's paw theory. It's a cat's paw theory. That's
Right.
what it is. That McCarthy's alleged bias through that letter.
Mm-hmm.
And I believe that has or should be directed out. There's no evidence from which a fact finder could find that McCarthy's letter, which was accurate. It's all cat's paw. The letter's accurate. There was an investigation done. If the cat's paw theory is out, then the flag has to be out, and you have to. And I ask you to instruct the jury that the flag is not relevant to anything in this case. I mean, there's got to be a major curative instruction. It's an incredibly explosive thing, and there is zero evidence from which you could have attributable bias of McCarthy. This is what we've been arguing about the last 2 days, I think, is how do you get that? How do you get cat's paw from McCarthy when it meets none of the elements?
Okay, I appreciate that. But let's start off with that because that was a question that I raised, and as I recall, I was asking the supervisor question aside, and here Attorney McDonough decided to Corriglia, which seems to expand upon this need that it be a supervisor. I asked where is the incorrect statement, and it was Attorney Ryan, I believe, who pointed me toward, was it was in the narrative.
It was in the narrative, Judge. Can I have the floor?
Go ahead.
It was in the narrative, and he references Clark, saying that Clark, saying this officer,
Right.
knows of 4 or 5 other occasions in which this happened. Clark, the next paragraph down the narrative, says he only knows of one that
Right,
was
okay.
years ago. He references Clark.
Okay, we don't need to revisit. I recall
Yeah,
that.
yeah.
I think that I only raised that because that I believe has been addressed.
But, Your Honor, it's relevant because McCarthy's identified as the complainant. McCarthy's the senior badge in that building. The department identifies him as the complainant in their own IA. We didn't identify him as a complainant. They did. It's also relevant, Your Honor, with respect to the failure of the department and the failure of McCarthy to take any other action. Clark was his subordinate. There's 0 words in the record, there's 0 words in the case, there's 0 words in the file from McCarthy with respect to his own subordinate and his subordinate's very clear violations of the laws of the Commonwealth, the work rules of the department, and so this
Okay,
again...
I'm not sure what that has to do with Mr. Buchanan, but
It shows that McCarthy is operating on a differential, disparate basis with respect to his subordinates who are white and this other person who he doesn't supervise who is African American.
Okay, I'm going to back us up here, okay? I just addressed that only because it was my recollection that had been somewhat addressed. I'm going to move us forward on all this, okay? Attorney Kitson, I'll give you an opportunity to rebut after I go through all of these with Attorney Ryan, okay? All right, I'm taking these in the order in which they were presented. First, on the response to the motion for directed verdict relative to the shortlist in 2014, okay?
Your Honor, in our view, the 2014 shortlist to the September-October 2015 promotions are one discriminatory action. The evidence shows, both from Todd Dodge and from Chief Williams, that Buchanan was referred to as lazy, doesn't fit the bill. Dodd added the additional language, see what you can do to get around civil service. And so that's occurring in the fall of 2014 when there's an active, viable list with Buchanan at the top. To the extent the mayor acted, well, the mayor admitted he has a prejudice. He's prejudiced in favor of veterans. He admitted the veteran had his preferential his points. So he's admitting a prejudice. Clearly he's acting upon reasons given to him by the chief that he's lazy, doesn't fit the bill, let's see what we can do to go around it, and they agreed to do the assessment center. So he was acting pursuant and in accordance with the chief's direction, Your Honor, and I would submit that this argument would be improper, as the appeals court accepted a similar argument in the case of Brownlee v. Kanzaki, 44 Mass. App. 408, where you had a termination over a period of years that the court said all can go in as one question, and it is one act of discrimination on a termination case.
Okay, bear with me a moment, please. Thank you for that. And then I want to move on to the next issue here, please. One moment, please. Okay. Next. Where is the evidence that the mayor's decision was the result of racial animus? This is talking about the promotion off the short list.
Your Honor, the fact that he didn't, as of that time frame, in the fall of 2014, it's clear that the chief was opposed to Buchanan's candidacy. And the chief's opposition, for the reasons he gave, can be attributed to the mayor.
How's that?
Because the mayor was acting pursuant and in accordance with, they were acting in union, Your Honor.
So then here again, we need to demonstrate that there was some inaccuracies in what the chief said to the mayor. So what are those?
Well, the inaccuracy would be the lazy doesn't fit the bill, Your Honor. That's the inaccuracy.
Where's the evidence that the chief said that to the mayor?
Your Honor, the mayor promoted in February, as we all know, off the short list. The decision not to promote off the short list.
Please give me months and year. February of 2015, I take it?
No, February 2014. Your
Okay,
Honor.
for Westerling.
For Westerling.
Okay, if you could just be a little clearer.
I'm sorry, Your Honor.
Okay, so the mayor appointed Westerling in
February 28, 2014.
Go ahead.
And by October 2014, the language is Buchanan, who's at the top of the list, is lazy, doesn't fit the bill.
Right. But the question was, how is that attributed to the mayor?
Because the mayor approves the course of conduct to go around and to do an assessment center, Your Honor.
Okay, all right. One moment, please. Okay, let me get to the next one. And I am truly trying to move us forward because it's 12:20. Hold on. Okay. Okay. Where is the evidence that the assessment center was rigged?
Your Honor, it's part of the one process. It's part of the whole process of the replacing Buchanan at the top of the list and pushing him back to third. So it's one action, and that action ends when you have a result where Buchanan's number 3 on the list instead of 1.
Okay. So it's still part of what you're alleging is the October 14th to December 15 process.
Correct, Your Honor.
Okay.
It's October 14 to essentially October 15.
October, okay. And
That's when the promotions were made. September, October.
You're talking about 2015. Okay.
15. The what you just referred to as promotions that were made, those were when he was listed number 3.
Correct, Your Honor.
What was the date of that?
I believe it's September, Your Honor, the actual promotions. It's in the books. It's either September or October 2015. We can get you the exact date.
Okay.
One of the exhibits does show it.
Okay. Okay. Let's move forward.
And then the next action, Your Honor, with respect to Ms. Buchanan is the November 2018 IA.
Let me just, if you don't mind, because I am typing this up literally in the order in which they were argued so I can make some sense of my notes. So just bear with me a brief moment, okay? I'll give you an opportunity to be fully heard. There's no evidence that the decision to initiate the IA regarding the stop was discriminatory, okay? So your response to that, please.
I submit it was, Your Honor. I submit it was because we have 2 members of the command staff, of a very small command staff, who both agree that the chief told them Buchanan's lazy, doesn't fit the bill. And then several months later, you have this stop that the chief then orders an investigation, and they go forward with this significant investigation in which 13 people are investigated. They go up to Stop and Shop to make sure the $10 gift card hasn't been used. And so the disparate treatment, the focus that they have here that they don't have on a lot of the others, I suggest.
Okay, I understand. You said two people said that Mr. Buchanan was lazy and doesn't fit the bill.
Chief Williams.
Okay.
Chief Williams.
And don't forget Todd Dodge.
Okay. Hold on. Okay. Third, or next, the decision to punish. An acknowledgement that the issue of the 3-day suspension in 2015 goes to the jury, but the demotion from provisional sergeant does not go to the jury because the arbitrator upheld it. Okay, your response to that, please.
It absolutely goes to the jury, Your Honor. The chief didn't have to impose the punishment he did. It was the chief's election to punish when, for obviously many more serious actions, no punishment was imposed. So it's absolutely a question that goes to the jury as to was the punishment fair, inappropriate. The arbitrator has determined that the 3-day suspension was unfair, but the punishment is fair game for this jury.
Okay, next. One moment, please. Okay, so now we're at the 2018 IA that was initiated by Officer Green. The allegation, or the argument rather, is that there's no evidence that that IA was motivated by race, no evidence that Donovan, who issued the letter or recommended the letter of reprimand, was motivated by racism. So your rebuttal to that argument, please.
Your Honor, the investigation was initiated by the chief. Donovan didn't do it on his own. He was hired by the department to do the investigation. So it was initiated by the chief. And again, Your Honor, they want to suggest that Jeffrey Soto, the fellow who arrested LaFlamme, kneed her in the back, laughed about calling DCF.
What?
It's in the report.
You're talking about student.
No,
Well,
but
I guess we're...
that he was bullied by Pat Buchanan when Pat said, "Come and do roll call."
Okay, but I guess what I'm looking for is evidence of the chief's discriminatory animus, mindful that 4 years earlier there was a comment that was made. What other evidence
So
are you arguing?
in October 2018, Your Honor, the evidence, I believe, is that the chief admitted that the assessment center list, which would have had a life for 3 years, was coming to an end or had expired in October 2018. And so if you remove Buchanan, he wouldn't have to, they could appoint someone else. He was appointed because he was number one on that assessment center list after the Haskins and Road promotions. He was the next man up. By getting him out of there, you now have the ability, and they did use it subsequently, to promote Road and Rowell as interims.
Okay, and you're harking back in terms of evidence of discriminatory animus to that same time period running up till around October of 2015. Is that correct?
Also, Your Honor, the case was in progress, and so I suggest there's also a retaliatory motive.
Okay. Okay. Next.
The last one would be the...
I got two more. Bear with me. 2019. There's no evidence of racial bias in Mr. Buchanan's demotion to provisional sergeant.
From provincial sergeant.
Demoted from provisional sergeant because there was testimony that otherwise that they needed patrol persons and that the earlier statement had been made 5 years earlier. So, your response in that regard?
Your Honor, I believe it's a follow along with the retaliatory IA that was initiated just months earlier.
This case was pending at that point in time.
Yes.
Okay.
And
it'd be helpful here, as you did with the earlier event, are you arguing that part of your cause of action here is not on the discrimination but on the retaliation?
The step down and the 2018 are more in the nature of retaliatory.
Okay. Anything else in that one before I get to the last one?
No, Your Honor.
Okay. All right. Okay. So 2020 to 2021, when Mr. Buchanan was number 5 and they hired number 6, or they promoted number 6. Okay. Who was that, by the way? Who was number 6?
I believe it was Chris Rowell.
Rowell. That's okay. Okay. So your argument in that regard?
Your Honor, that was solely the chief. The mayor, when she was here, testified she had never seen the evaluation or the scoring document until she was here in the stand. She had no idea who was being promoted or who the other candidates were. She had no idea that they were bypassing Buchanan. And up till now, the top guy got it. And here, Your Honor, it was a free off-ramp. It would have cost them nothing. And they couldn't bring themselves to do it.
Okay. And the evidence is, as you had suggested earlier, was this October 14th through October 2015 evidence of bias, and that this reaches forward to demonstrate some level of ongoing racial animus.
Well, with respect to the 2020, yeah, Your Honor, 2021, he's the next guy up, and he's denied the promotion in favor of a lower scoring white officer.
Okay. All right. Thank you. Now, is there anything further that you want to say before I move us forward?
On the directed verdict? No, Your Honor, I think we've covered it.
Attorney Kessin, if there's something different that you wish to add, I'll hear from you. Otherwise, I believe that I've heard enough, and I appreciate both lawyers fleshing this out nicely. So is there something different that you want to say about one of these particular causes of action, so to speak?
I want to highlight the cat's paw theory of McCarthy, because that flag is so inflammatory, as you know. We have been arguing that should never have been introduced in the first place. And it's not just the fact that he said one, that he heard there were 5, but there was only 1, and later found to be 10, is absurd. If the only way it works, the theory is if the mayor or if the chief relies on McCarthy's materially false statements and does something bad. In this case, there was a comprehensive investigation which expanded the stuff. There's no chance that this is cat's paw. And the only way they get to continue to wave that flag in here, which has nothing to do with this case, is if you let them argue, if that claim somehow survives, that first they argue McCarthy's the racist who infected the chief, then the chief becomes the racist.
Your Honor,
No.
So, Your Honor, on the cat's paw theory, there's multiple prongs. What McCarthy said was not materially false. McCarthy did not tell the chief.
Well, what about, their rebuttal is that in the narrative, Ryan Clark is quoted as saying that there was one issue. McCarthy said there were 4 to 5.
And then they investigated, and there were 10. That's the issue. When they investigated, Buchanan admitted to 10. They did not rely ever on the statement that Clark said that McCarthy said that Clark said 5. It was never relied on.
Where is the evidence? I know it's there, but I'm asking you to identify it for me. that supports that last statement that when they investigated, there were 10 other incidents. So that was part of the IA.
Yes, sir, and I'll point you to it.
And it's in the
Part of-
interview. It's in his interview too.
and I think Buchanan's interview.
Okay,
In the IA.
but where in the book?
It's in the,
Well-
I believe it's in the report, but I also.
We'll take, no, we will point you, we'll look it up.
Okay, so the argument here is that there needs to be a misrepresentation. And Attorney Ryan argues that there was a misrepresentation because Clark told the lieutenant that there was one, and McCarthy said that there were 4 to 5, but your rebuttal to that was that actually there were 10.
And even if there was, yes, there were 10. There is a complete, because you see, Your Honor,
Is the
cat's paw, yes, sir.
Yeah, just one moment, please. Hold on, I just want to see something here. What exhibit was the McCarthy letter? Was it 7 or so? Or wait, no,
Supervisor
It would be-
and investigation.
2. Yeah, 2. Okay. The quote is, "This officer, who I take it is Clark,
Yes.
in and of itself, I did not find a problem until this officer also said that this is the 4th or 5th time that he has heard that Officer Buchanan has made these types of stipulations." So your argument is that that's not what Clark said. Clark said that there was one, and Clark is not a witness here. Your argument is that it really doesn't make a difference what Clark said because the reality is that there were 10.
And even if that's, the fact they investigated ends it. The only way cat's paw works is Alexei Keston tells Erica Brody that I did terrible, I had sex with sheep because he doesn't like me because I'm Jewish. He's a bigot. And Erica Brody ignores, doesn't investigate, doesn't check any of the statements and acts on it. That's how cat's paw works. Here, they started an investigation. They investigated all of it. They did not rely on McCarthy's version of the facts in the slightest. McCarthy reported hearsay. McCarthy told them that Petullo talked to Clark, and that's what she said. That's what Clark said. Do with it what you will. He doesn't say you got to fire this guy even. So they then investigate. That cuts off any cat's paw theory. The cat's paw theory doesn't work in this case.
Okay,
Plus, he's
and
not a supervisor.
do you have a cite for me as to the? I know I've got a couple of cases I've looked at on cat's paw theory, but one particular one that says that there is no viable cat's paw claim if there's a subsequent investigation.
Ms. Brody?
Judge, we cited a bunch of cases in our motion for a directed verdict. If I may have a moment, I can pull them up.
Well, bear with me a moment. Let me get that in front of me. Hold on. Right, I've got your motion here. Can you direct me, perhaps?
Sure. On page 3,
Okay. One moment. There are 2 motions. I apologize. Okay, this whole paragraph then. Okay. The Mole case, etc.
Mole, Banks.
Yes,
Yeah.
the rubber stamping of false information. That just didn't happen.
All right. Let me just focus. Let me drill down a little bit on that particular issue. Attorney Ryan, what's your response to that legal argument? And let me take a look at this paragraph, please. It begins under the so-called cat's paw theory. Okay, so the employer can break this causal connection by showing that the decision maker conducted an independent analysis and was not rubber stamping. Okay, bear with me a moment. Okay. Okay, so that squarely supports what you've just argued. What's your response to that, Attorney Ryan?
Your Honor, the Staub case, and I believe it was cited in. Yeah, Staub was cited. I believe it's in Bulwer.
Okay, hold on a brief moment. Let me just do something here. Okay, I'm sorry. Okay, what is the case, please?
It's Staub versus Proctor Hospital, Your Honor. It's a U.S. Supreme Court case.
Is it cited in someone's brief?
No, Your Honor, it's not. But it's cited either in, and I'm looking for it now, either in the Bulwer case or it's cited in Verdrager, Your Honor.
Okay, see, Bulwer, I've got
Verdrager here.
Okay, what? Bear with me a moment.
Here, this is what he said. He said that he was done with over the last 2 years, maybe 10 people. But he said.
All right, do you have a page on Bulwer?
No, Your Honor, I'm struggling to find it. I will freely read it.
All right, and the Verdrager case, how do you spell that, please?
That's V.E., that's the Ms. Levin's case.
Verdrager,
Yeah.
that's the Mintz-Levin case, okay, yeah. And if you have that site, I know that we were looking at that yesterday, but if you have that site, that would be helpful.
The site, Your Honor, is 474 Mass, 382. But I can't.
Okay, I'm going to take a look at those cases. Did you say 47 Mass 3282?
Oh. 474-382, Your Honor, on Verdrager.
Okay.
And I'm looking at it now, so it's on page, it looks like page 798, where it's quoting trustees of Forbes Library as well as the Staub versus Proctor case.
Okay, I've got Forbes Library here. At what page is it quoting it?
In Verdrager, or what?
Yeah,
page
Verdrager.
of Forbes?
403.
Well, what page in Forbes is it cited in? What page in Forbes should I look at?
It's citing to 569, 570.
403.
But what the court says in Verdrager,
Because what I'm focused on is the investigation issue. That Mole, based upon the defendant's motion, establishes that there is a break in the cat's paw where there's an investigation. And that in this case, McCarthy made a comment, which even if I'm to say would attribute bias to the decision maker, was severed because there was an intervening investigation, the IA. What I'm looking for is your response to that legal argument. And let me say this, I guess to be fair, I think that defendants did raise this at one point, but we haven't drilled down on it yet. It's an important issue.
so it's both in Verdrager. Verdrager is where it's at, Your Honor.
Okay, and what does Verdrager say in that regard?
Where the decision maker relied on recommendations of supervisors whose motives were impugned, the motives of the supervisors should be treated as the motives for the decision.
Right, and intervening investigation is the issue here. What does it say about that?
It says that the employer may not insulate its decision by interposing an intermediate level of persons in the hierarchy of the decision and asserting that the ultimate decision makers only acted on the recommendation.
That articulates cat's paw, but it doesn't articulate when cat's paw is severed.
And in Verdrager, they argued that the cat's paw was severed because they argued that Mr. Papio and the others were not her direct supervisors, and therefore, and they did an investigation.
Okay, let me leave it at this. I have to look at. I haven't read Verdrager yet. I'm going to have to read it, but I'm focused on that particular issue. Okay. I do want to move us forward. We've got 15 minutes, and I want to take. I'll hear from you, but
2 seconds.
yes.
McCarthy didn't recommend anything. All these cases are about people with bad motives telling people to fire somebody, and McCarthy didn't recommend a damn.
Okay, I think I know what your response to that would be, so I'm going to move us forward.
Yes, Your Honor.
All right, now, I want to use the opportunity of outlining as carefully as you have, and I sincerely appreciate it, the various jumping points to talk about your special jury verdict slip, because I would like you to work on it in light of what we just discussed. Because it's even more complicated, much more complicated than I actually envisioned now that I've got this charted out, okay? Simply put, a jury may find, for example, that there was no discrimination relative to the period of 2014 to 2015, just for argument's sake, okay? But later on that there was, or vice versa, okay? And that needs to be separated out, okay? And you have all just gone through and identified these different points. I'm not going to repeat them, okay? You know them much better than I do. And you've argued them. And I would suggest to you that each of them, and I'll drop a footnote here in a brief moment, is deserving of some a question. Mindful that the plaintiff says for this whole year period in 2014 to 2015, it was a continuum. That I get, and I get that the defendants break that down, okay? I can make a decision in that regard as to what's going to go to the jury. So I don't think he really needs to belabor that particular argument. Of reading through your proposed revised drafts, I see what you've done. But after that, there are separate incidents, it seems to me, and the calculation of damages flows from each one. Having said that, I'm all for having only one statement of what the damages is. I think you all agree in that regard. No one's actually asked separate damages to be set forth. And if you want to pitch something to me, I'll look at it. But if you have, for example, that from the earliest cause of action, yes, there was discrimination. Okay, does that mean that the damages stopped when he was promoted? So I'm not quite sure how to parse that out. And the overlapping of those damages will become a real mess for the jury to navigate. And at least in your initial draft, I didn't see separate line items for damages. And while initially I thought it would have been neat to have that, I did comment while I was thinking it through that I don't know how the jury is going to do that. So just think about all of that. Yes, Attorney Keston.
I have an idea. If the jury breaks out, assuming they win anything, if the jury breaks out emotional distress and lost wages, then we'll know.
Yeah, I mean,
Because
I guess, you can say if you find there's been emotional distress, yes, how much, and then what period, or for what period of time.
what I'm suggesting, Your Honor, that just on when we have just one damage thing, that we say how much for emotional distress, how much wages. By seeing what wages they awarded and checking their when they found discrimination, we'll know if they did it right. Because I'm assuming there is evidence from which they can actually do that.
There is. I guess all I'm saying, and I would like to look at something on paper. All I'm saying is that my concern relates to overlapping damages. Okay?
Well, I think they have to be instructed. But what I'm saying is, we need some kind of breakup to figure out what they did.
And that's for you all to work on.
Yep.
So you've got some guidance from me. I do have, as I said, a hard break at 3:20. Otherwise, I'm all yours. And I'm going to ask you to work on those issues. And as far as our jury charge is concerned, our jury charge conference, I don't see any need for me to hear anything further. I'm going to draft up my jury charge. I'm going to hopefully get it to you by the end of today, since I'm not around Thursday and Friday. But if need be, I will arrange to have it transmitted Thursday or Friday. You'll certainly have it no later than Friday. But then on Monday morning, while I'm not going to, mindful that your formal objections to the jury charge will be lodged after I give the jury charge, and I'll give you plenty of time on the record to establish your objections, okay? Prior to the closing arguments, if there is a request for, I'll call it clarification, okay, then I'll entertain that, but I'm not going to entertain wholesale re-argument, only because we just don't have time and it wouldn't be efficient. I hope you can respect that. So you'll have plenty of time to shape your closing arguments accordingly. There is one other thing I'll say. I always give, we like to call it the silver bullet closing argument charge, which many of us do. You may have heard it elsewhere. Basically, and I give this right before closing arguments, and I tell jurors what permissible argument is and what it is not, and so that an attorney, for example, may not express, let me see if I can pull it up, his personal opinion, and if an attorney does that, you're to disregard that. An attorney may not argue facts that are not in evidence, and if an attorney does that, then you should disregard that. Hold on a second here, as it's pretty short and vanilla. You're about to hear closing arguments. This is an important part of the trial, and I say why, what's going to happen. And I say that this is not evidence, lawyers are not witnesses, the evidence has come in, blah, blah, blah. And then attorneys are not permitted to refer to facts not in evidence. If based upon your memory and understanding, lawyer does this, you should disregard the comment. Attorney is not permitted to express their personal beliefs in the credibility or lack of credibility of a witness who testified. That determination is for the jury. If a lawyer makes such a comment, you should disregard it. Decide the case based upon admissible evidence. Attorney is not permitted to persuade you for or against either party by appealing to human passions or prejudices. If you become conscious of any such passion or prejudice as you consider your deliberations, you have to put those feelings aside. If a lawyer makes such a comment, you should disregard that comment. So it's pretty Hornbook law. So I'll give that. We'll start off with Attorney Keston. What I'm recommending, just because we want to keep this moving, mindful that this is a complicated case, I thought that 45 minutes for each table, so to speak, would be sufficient. Personally, I think anything longer than that, you can begin to lose these people. So 45 minutes for Attorney Keston on behalf of the city and the chief, 45 minutes for both counsel, plaintiff's counsel on behalf of both your clients. You could divide it up any way you wish. I take it that's sufficient.
Yes, sir.
Okay. Then what will happen is we will take a break, and then I'm going to charge them. I'm not going to give them a copy of the jury charge to read while I'm charging them, because they're going to be typos in it. I guarantee you that. And so instead, I will read it to them, and I will be making corrections as I inevitably will find them. You will have copies for yourselves to read along. And then they will. I'll tell them that they're going to get. I don't have copies we deem appropriate. 3 copies, 4 copies. I'll then make the quick typo corrections. We'll mark it for identification purposes. You'll approve it. It will then go into the jury deliberation room with them. I need you to make sure that you have checked on all exhibits so we don't lose too much tread there. Is the issue of these CDs and the CD player. Let me just ask Mr. Jakonowski. So I just kind of presume that we don't have a way to play things other than on a laptop. I take it that TV is just hooked up to laptops. Is that correct?
This TV?
Yeah.
Yeah, is to one of these computers.
Right. Yeah.
Hey, I mean, we're going to try to, we downloaded the stuff into a CDR, and it's not played on the boombox, we're going to see if we can find something that plays it. Another alternative, Your Honor, which I've seen in a lot of cases, is that if the jury wants to hear something,
They can come into the court.
They come out and you play
Yeah,
it.
we could do that.
And we have more control.
We could do that. I've done that. We could do that.
I do want to be heard briefly on the Dodge claim.
The Dodge claim, yes.
If you want, we have the audio teed up of what he actually said that he didn't say to the chief. They never protested.
I'm sorry, I didn't.
He never protested. He never refused. The question of what did he tell the chief when the chief said, "Is there some way around civil service?" His testimony, I have it. Secondly, though, Your Honor, are you intending to have the jury decide whether the arbitration, whether the grievance is a whistleblower? It seems to me it has to be done as a matter of law. We have two letters.
I have not decided. I have not ruled yet on your motion for renewed. Your renewed motion for directed verdict. Okay, that is one of your arguments. Okay, and I'm aware that is an issue.
Okay, I mean that's what I want to raise. Is I cannot imagine that a jury gets to decide whether a letter that's in an uncontroverted letter is somehow a whistleblower.
SJC's already said it is, Your Honor.
Okay.
Ordinary letters in your court.
What is the site?
Edwards versus Commonwealth.
Okay, hold on. I got Edwards here. Hold on.
The same challenge was posed by the Commonwealth. Documents submitted in her
Okay,
ordinary.
I just want to take a look at the case. Bear with me a moment, sir.
Yeah. The communicated that she thought the decision
Hold
was
on.
legally erroneous. Because of the issue.
One moment. Was Edwards attached to your opposition?
Yes.
Okay.
Yes.
That's what I saw. Hold on.
Oh, yeah, it's here. Okay, but-
Right. If you can direct me where it is in your packet, please.
Page 569, Your Honor.
Here's Edwards. Okay.
Plaintiffs'
Okay.
writings.
All right. I'm not there yet. Hold on. All right. Page 569. Is that what you said?
Yes, Your Honor.
I'm looking at page 11. Oh, here we go. Okay. 569.
Commonwealth
Okay.
argued that
Right.
writings submitted in plaintiff's furtherance of her ordinary
Okay.
duties didn't suffice.
All right,
SJC
right.
said it may suffice.
Okay, one moment. So you're under protected activity, and the paragraph that reads the Commonwealth argues, right?
Yes, Your Honor.
All right, one moment.
Yeah.
Okay. Right, and this has been already argued.
Yes,
Okay.
Your Honor.
So, and I recall that argument, and I'll take a look at it. Okay. All right, so, it's now 1 o'clock. I did indicate that if Attorney Keston wishes to be heard relative to your supplemental, submittal, I'm happy to hear it. To be honest, I'm not so much focused on your arguments at this point as much as what it is you're seeking to put in, and what you're seeking to put in, as far as I can see, are portions of the statute.
Yes, Your Honor.
And I guess the question is simply whether or not B1, B2, and B3 all go in. And I've heard enough about whether or not those various prongs go in. So I'm not quite sure I need to hear anything more in that regard. But certainly I'll give Attorney Keston the last word in that regard. I'll ask you to continue to work on your jury charge, your special jury verdict questions, and I will now go work on this charge. I'll see you at 2 o'clock, okay?
Thank you, Your Honor.
Thank you.
Yep.
I'm sorry you have to type it.
I'm a very fast typist.
I'm so sorry. I mean, it's what they've done to the Superior Court is
The
not
best
right.
course I ever took was Mrs. Tegnell's 6th grade typing course that has stayed with me for life.
Your Honor, they took it in 8th grade primarily to be with girls.
Oh my God.
What?
It was an all-girl class, and I said, I'm going to take it. That's why. I'll tell you the truth. That's what I was thinking. But it's been
It was a required course.
Really?
Yeah. Very smart school.
I was made a lot of fun of for taking that course in Watertown High School.
All right, very well. I'll see you all. Welcome back, everybody.
Hello.
Okay. Superior Court is now back in session, 82.
Again, we're back on 1780 CV 033, Patrick Buchanan et al. Versus City of Greenfield. We're with counsel only, no juries in the courtroom.
Okay. I continue to analyze the issues that you've presented. I've got a couple of questions I would like to explore. I reviewed the Mole case, and perhaps maybe it just wasn't as cogently set forth in the motion for directed verdict earlier. For that was truly the first time that that issue was highlighted for me. And as to Sergeant McCarthy, I am satisfied that there was an intervening independent investigation, which was the internal affairs investigation, and that under Mole and the other cases that are cited at page 3 of the defendant's motion for a directed verdict, I'm not considering this as a ruling in the motion for a directed verdict, but I'm considering it insofar as the jury instructions reach this issue. I'm satisfied that the issue of attributable bias flowing from Sergeant McCarthy to Chief Haig doesn't withstand muster because there was an intervening investigation under Mole. And by extension, then, that this whole issue with the Confederate flag is overly prejudicial and not relevant to the extent that there is no attributable bias that I would attribute to Sergeant McCarthy. So I'm going to include in my jury charge specific language that any evidence that related to the Confederate flag at Sergeant McCarthy's premises is not to be considered and not considered as evidence and put out of the mind, etc. Okay? You said something, Attorney Ryan, for the first time about attributable bias flowing from Chief Haig to the mayor. Okay? And that was the first time I heard that. And I didn't think that anyone was arguing attributable bias from Chief Haig flowing to the mayor, but certainly got thinking about it as I was getting ready to delete the provision on attributable bias in my draft charge. And I guess the question I have is whether or not the investigation, intervening or not, has the same effect on a claim of attributable bias flowing from Chief Haig to the mayor. But first, since it was Attorney Ryan who raised it, understanding what I've just said about attributable bias vis-a-vis Sergeant McCarthy, are you asking that I give an attributable bias instruction vis-a-vis Chief Haig?
Absolutely, Your Honor. Respectfully, we object to your ruling, but
Right.
It is what it is. But with respect to the chief's the one, Your Honor, who put in motion all of these things through his statement that he doesn't fit the bill, he's lazy, see what you can do to get around.
I get that part.
Yeah. And so the mayor then acts on it, Your Honor.
I guess the issue for me is the mole issue, okay, if I'm pronouncing it correctly, which I get and can accept that there were statements that may have been allegedly born of discriminatory animus. The question is whether or not there was, and I don't know if it needs to be intervening or concurrent or whatever have you, an investigation, an independent investigation that would effectively sever the cat's paw in relationship to Chief Hague and the mayor. Because this certainly was an investigation, but it seems to me it actually preceded the communication to the mayor, or maybe it was concurrent. But
I believe it was concurrent, Your Honor, and these things were all happening at the same time. Clearly, the investigation as to Buchanan's alleged wrongdoing has no bearing on the workaround. And we submit that the workaround, the list, was evidence of discriminatory racial bias.
I'm only talking about attributable bias. All I'm talking about is the jury charge that relates to attributable bias, that would attribute bias from Chief Hague to the mayor.
Yes, Your Honor.
Not, I mean, you're free to argue,
Yep.
workaround or whatever, discriminatory animus, okay? Let me turn to Attorney Keston, and I don't want to belabor this because I'll just be honest, I really need more time to get back into my lobby and continue doing research, etc. Am I correct? My sense is that the investigation relative to Patrick Buchanan, which was either concurrent or ongoing, or just wrapped up, fits within the ruling in Mole, such as to sever a cat's paw between Chief Hague and the mayor. Am I correct?
Yes, of course.
Okay, then I'm not going to include. I appreciate that. I'm not going to include the section on attributable bias at all. Then, okay, and it was just an appendix there because you had just mentioned it. It's the first time I heard it. So that's going to be excluded, okay, from the jury charge. I'm still looking at the unexamined bias issue. I haven't gotten to that yet. The retaliation, the 151B retaliation. You know, the model doesn't have a mixed motive theory in it. Are you asking that I include it?
No, Your Honor, not for retaliation.
Okay, well, that makes that easy. Thank you. Okay. All right, great. So bear with me a brief moment, please. Okay. I have not gotten to the issue of whether or not the grievance constitutes an objection or refusal, so I don't have anything for you in that regard right now. And that's all that I have before I turn to you. The first thing I want to do, if possible, I'd like to wrap this up in 15 minutes because I've got something at 3:30 and I kind of need to prepare and make some phone calls for it. Is see whether or not Attorney Keston wishes to be heard relative to Attorney McDonough's arguments. Let me just say this. I appreciate the arguments and I appreciate the case citations. And I've heard the arguments, I think, from both sides over the course of nearly an hour yesterday. I don't know how much more needs to be added. Okay. So, Attorney Keston?
You mean on Dodge?
Yeah.
Yeah. Your Honor, we listened to the tape. Lieutenant Dodge testified that he never said no to the chief. He never said anything to the chief. That's as to the conversation they had in 14 when he said the chief said, he said, did you say anything to the chief? He said no. So there can't be a whistleblower there. So
Well, what about, Attorney McDonough's argument is that that's a refusal.
Yes. Your Honor, if you listen, I have it. I'll send it to you. I'll send it to them. He didn't refuse. He didn't say he refused. He said there's nothing was to be done because it was all legal. He never even hinted that there was anything wrong. He never said that.
Do you have the time on the timestamp or a quote of what he said?
Yeah.
I just had it up. I just restarted. It's the 21st,
11:46.
11:46 or so, right around there.
That one.
And if you listen to it, it's crystal clear. He never said he said anything. I didn't say
Okay.
anything. Not
All
that
right.
he refused. He said there was nothing to be done.
I understand.
And we worked on getting an assessment center together.
Okay. Can I just, am I correct that your argument is that it may be that he said nothing, but that in and of itself is a refusal?
Absolutely.
Okay, so we've
I think
argued
there's
this,
more
so-
to it, but yes.
What is,
absolutely.
okay,
Because there's another grounds for refusing in the statute. They can't. This is B3 we're in now, non-cooperation.
Right.
Once you ask someone to participate in legal activities with you, an employee.
I'm sorry, I didn't catch what you
Once an
said.
employer asks an employee to participate in illegal activity under the three cases cited, Malik's, Edwards, and I think it's Quartz, and they don't, and you punish them later, you've made them a whistleblower because they didn't cooperate.
You've
with
made them a what?
a whistle. You've put them into the protected category, and as Dodge said up here, he indicated he's not going along with it, and then he actually was on the other side of it through the whole adversarial process.
Okay, I'll take a look at those cases.
It's just not true.
Yes, it
He's
is.
not mixing the
He's the one
grievance
that-
of discipline.
Just a brief moment, one at a time.
Dodge never protested an assessment center. He never protested anything.
Okay,
When he's, and if you listen to it, Your Honor, you have, I assume you have access to the audio recording, not the
of
tape.
course.
As we do, and if you listen to it, it's crystal clear that Mr. Dodge chose not to say a word or do anything.
Okay,
And said there was nothing to be done.
I've
It's a
heard
fact
it.
issue for the jury.
No, it's not.
Okay, I've heard enough on this issue. Thank you. Okay. All right. Hold on. That takes care of that. Now we're back to your proposed verdict slip. Did you make any progress?
Yes.
You're kidding.
All right, no,
We're not sure yet, Your Honor.
we have.
Taking the question off, and we're narrowing it.
Okay, you want take as much time as you want. I'm
No,
here.
We're not gonna agree. I think we're at the stage now we're not gonna agree.
Well,
So-
what can you
but
give-
We have two ones that are close.
Yeah.
Okay, why don't you show me what you have?
Okay.
Okay?
So
The one I just sent to,
Also, please email them to the clerk in Word format so I can cut and paste them.
yes, sir.
Hampshire.clerk.
So one of the issues, Your Honor, is the
I
privilege.
do want to get in front of me
Yeah.
before we dive in, okay? So, do you have hard copies?
No, you're not.
no, but
Okay.
we can send them to you right now, Judge, if you like.
Why don't you send them in? I'll step off. And then, Harry, if you can be so kind as to print off maybe, 3 copies. I need to look at a physical hard copy.
Thank you.
And then I'll step out. I would be very happy if we could wrap this up, as I say, in 15 minutes. Okay. All right, good.
Thank you.
All right, I'll step off then.
Thank
I'll
you,
get
Judge.
rid of these old ones.
Michael, you want me to send it?
All right, please.
You're the fastest judge I've seen.
Back in session.
No,
You know what?
the way you come back and forth.
If you all have any idea of the multitude of other cases and matters and tasks that I am handling nearly simultaneously with this, you would absolutely. The word is brech, which means vomit.
Or in Surus.
So, okay. I got 2 attachments on your email, Attorney Keston. Is it just one proposed verdict slip?
Yes.
Okay. So then I will take that. Take that out. Okay, we'll focus on this. I can give you 10 minutes. I did look at plaintiffs. Let me see. I've not yet looked at defendants. Okay, so the first large distinction is defendants break out the separate incidents in 2014 and 2015 to 3 separate incidents as opposed to just saying during that time period. Is that a fair characterization?
Yes, sir.
Okay. Okay. All right. Let me ask, Attorney Ryan, is there anything factually incorrect about questions 1, 2, and 3 that defendants have proposed, apart from the fact that you say that this was a continuum?
Your Honor, there's no damages for 2 and 3. And it doesn't ask the question as to the actual promotions which were made. They were actually made, and it's in the book, October 1, 2015. That's when they were finalized.
It doesn't ask any questions that were made about the promotions. Why would it's the demotion? So I'm not sure whether there'd be a question about a promotion.
Our argument is they failed to promote, and the promotional process was one.
Failure to promote. Right.
Yes.
Okay.
Yes.
I see.
Oh, yeah, and Your Honor, their other thing, the so-called short list.
Okay. All right. Bear with me a brief moment. And we're not going to resolve these issues right here. I just want to understand. Okay. Okay. Then let's take a look at your questions on plaintiff's side. 2 and 3.
Match with their 4 and 5, Your Honor. The wording, I mean, they've got Donovan, we've got the...
Okay.
Yeah, we're not that concerned about the wording.
Okay.
So.
All right. Bear with me a moment. Well, question 2 and 4 are a little bit different. Question 2 asks whether or not the investigation itself was initiated because of racial bias. Question 4 asks whether or not the discipline, which would have been the letter of reprimand, was the result of racial bias. So I think that they're cause and effect.
Yeah, well, I would take theirs 4 if we could just put racial animus or retaliation. I'd have no objection to that, Your Honor.
So question 4, as a result of racial animus or retaliation, and
Yeah.
you do, obviously you've articulated that. Okay.
That's to the discipline.
That has to do with the discipline, yeah.
Well, I think that's fair.
And take it as a...
Okay, that's great. Okay, perfect. Thank you very much. Okay, so 2's out, 4's in. 5, or let me take a look at 3. Did Patrick
Who's the
prove...
ones that we're looking at, Your Honor? I'm sorry.
I'm looking at question 2. Plaintiff's question 2 is out.
Yep.
Question 4 of defendants is in with the addition of the word or retaliation.
Yep.
Question 3.
Of the plaintiffs?
Correct, I'm sorry.
Yes, sir.
Did plaintiff prove that he was discriminated against, retaliated against in connection with the 2020-21 starts of promotional process, that he was going to retaliate in connection with 2021? Oh, they're the same.
Yeah.
Okay, so same as 5. Thank you. Then let's just look at your damages questions. One matter was you fairly for the discrimination or retaliation that you found. Okay, that's the same. That's the same. You did very well. Okay, amount, words, numbers, whatever.
There is a difference there. I don't know if you caught that.
Which,
What is that?
It's I think a scrivener's error, but it should be words and numbers for each amount, for each back pay. Like you notice that you only have 3 lines and we have 4.
Oh, okay.
I think it's
Well,
Yeah. I'm the scrivener.
it's. Do you want it in numbers and words?
That's to each.
yeah, I know what you mean. We'll add a,
whatever it is. Let's just keep
Yeah, I agree. No, I agree. That was my error.
This is the style.
It was the lemon blueberry cake with hair marker.
That's fine. Also, you've got question 8 should be question number 6. I haven't even checked these. Inevitably, this happens when you start cutting and pasting. So I'm looking at. Okay, I'm not even at question top dodge yet. Okay, so then I get back to question 4 and question 5. Question 4 plaintiffs and question 5 are the same, effectively. Okay, then okay, and then question 5 is punitive damages, and I respect that. I'll let you right now, I'm going to let that go to the jury. What they do with it remains to be seen.
You have time to change your mind.
Yeah, but I think it's fair game that the and in Haddad, the SJC pretty much said that inquiring into the malevolent intent or whatever might be of the defendant is a question for the jury. So, but whatever. All right, so that's the punitive damages, and you break that out. Now we get into Mr. Dodge.
Yeah.
And that's only against, obviously, the city.
Correct.
Retaliation against in violation of the mass. Oh, perfect. Isn't that nice?
I think we're in agreement there.
You are.
Yeah.
Well, you've got lost. You break yours out. Lost back wages and emotional distress,
Yeah.
which I'm fine with. Okay. So the only thing for me to ponder are plaintiff question 1 versus defendants questions 1, 2, and 3. I'm listening.
Your Honor, that's a scrivener's error. I did not mean to include anything about Dodge, but if I don't think Dodge can go to the jury.
I understand that. I respect that.
And if he does go to the jury, then there's got to. I mean, that's the question. Are we going to ask who's going to decide whether? There's 3 options. You could decide he didn't whistleblow and that's it. You decide, which I disagree with, that question goes to the jury. Or you can decide that you found that he did whistleblow and this is a causation question.
I'll hear from you.
Judge Graziano already decided in Edwards that the document submitted in your work scope and there a SORB officer's documents was not excluded from the conduct.
Okay, let me just tell you this, and I'm not, I've heard this argument. I haven't yet ruled, but I did read Edwards. And, Edwards isn't a case with a grievance per se, but it does talk about the more expansive reading of what objection means and refusal means, okay? So just so that you can prepare, I'm inclined to let this go to the jury, but I haven't decided yet.
Which question?
All 3.
So you're going to have the jury decide whether the letter of grievance, the grievance letter, there's 2 letters, right? There's one.
I understand.
Whether those letters constitute whistleblowing. Is that what you're
I just told you, I'm still pondering it, but because you need to prepare, okay? So that's where it is, because there's more to it than just the grievance.
Exactly.
Okay, it's not just the grievance letter, and that's what I'm pondering. Now, I do want to focus back on 1 through 3 because I truly do need to go soon. Okay, and I have not yet decided on that issue. I'm only telling you so that you prepare. Okay. Now, 1, 2, and 3. The characterization of the quote-unquote short list. It's been referred to as the short list because that was the list with just Patrick Buchanan and Haskins. Okay, so it has been referred to as the short list. What's a little confusing is that Westerling was also a short list. So the terminology short list is a bit confusing here. When in 2014, we're talking like October of 2014, because Westerling was February.
Correct, Your Honor. So, September, October 2014, and the promotions were made October 1, 2015. That's when they were finalized and they signed. And it's an exhibit.
So we're clear. Westerling was in February, was it?
228.
He was 228-14.
Correct. And the short list for Buchanan and Haskins came out in April. Regardless of the judicial admission.
Right. Oh, yeah, no, I understand
It's
that.
an exhibit. It came out as of April. And then if we get into that, then we have to craft a jury instruction that tells them that if there's 3 for the one position, that the city must appoint one.
This is what I'm just talking about. There's the issuance of the list and the failure to promote from the list. The list may have come out in April, but what you're asking for is the failure to promote from that list.
That
And
could be any time.
well, when was the decision made to promote someone else?
Well, it was finalized as of October 1. So it would have
October, year
2015, Your Honor.
Because of the
They
assessment.
passed.
Yeah.
on the list.
So they didn't promote off that list. They went to the assessment center, which was finalized in October 1 of
Okay.
2015.
All right. All right. Bear with me a brief moment, because if I allow these questions in, these truly are the sort of questions that will be fleshed out by your closing argument in terms of what they mean, because I presume that you're going to go through these questions with them. Number 2, did the plaintiff prove chief initiated the because of racial animus? Okay. And here, there's no true objection to this locus, but rather simply that your argument is that it was a continuum, if I understand correctly.
It's a continuum, and there's no damages for 2 or 3 per se. It's the end of the promotional process where he incurs damages that are finite.
One moment, please. Well, you all have damages lumped in, which is fine with me. Okay. I'm going to think about this. I'm inclined to allow in the defendant's version, and you can argue this was a continuum. Okay? But to the extent that there are some different dates associated with them, it might make a distinction. So I'll give this some thought. I thank you all for your time, for your attention. If you need anything from the court, just contact Mr. Jakonowski. I'll be in touch with him, and I'll get you something. It's not going to be today, but probably tomorrow. Okay?
Thank you.
Okay, thank you all.
Your Honor, have a safe trip.